When is it too late to ask the bank to call off or postpone the auction?
Well, it can be postponed right up to the moment the lawyer stands on the courthouse steps and says, I'm postponing the auction.
Do they have to start over then?
I'm sorry?
Do they have to start all the way over if they postpone?
No.
They don't have to start over the whole process. They just postpone the auction itself. And as long as they postpone it to a date within 180 days of the original sale date, then they just go back and stand up on the steps. And I mean, they have to re-notify people, but
Do they have to republish?
I don't believe they have to republish, but they do have to re-notify people of the date. And they might have to republish. We'll go through that a little bit more specifics on the postponement. But it's fairly simple to postpone them. They get postponed all the time. I mean, you know, I've postponed a number of them. And for whatever reason. I mean, you know, if there's a chance, I mean, if it's, the ones I've been involved in are hard money loans. And so it's, you know, we don't have these different divisions who aren't communicating. It's, gosh, we might get paid. Let's postpone this because I'd rather not have the property back. A couple times I've had clients who was like, well, no, actually, I'd really kind of like to foreclose on this, so let's not postpone it. Yeah.
Okay, back to when you basically said your seller is not going to even want to do anything with you. Can you have them sign off right there and say, just deal with my lender? And
Well,
then
that's
you
the
can-
letter of authorization.
Okay,
Yeah.
and then you don't have to disclose any, well, you don't have to get hold of them every time then?
No, you're not going to be getting hold of them
Anymore.
They're going to be ignoring you. They don't care.
They don't care.
They're going to show up at closing and
Just
sign.
make sure you have that signature saying you can deal with
Yes,
the lender.
yeah, and the lender won't talk to you without it anyway, so you're going to be getting it. I mean, after that first phone call, they're not going to talk to you again until they get that letter of authorization. Okay, so let's go into what the lender will do and what they won't do as you're negotiating with them. The very first thing you need to know is they're going to cut your commission.
Yep.
Okay. As I mentioned,
Well, then it's, only if you can show me a corresponding cut in your pay.
well, and yeah. So their idea is that everybody's taking a hit. Okay, they're going to take a hit. Everybody's going to take a hit. You're going to have your commission reduced. The lender comes back and says, no, reduce it by 2. Okay, so you're back to where you would have been normally. A couple times, though, I've seen lenders come back and say, you upped it by 1, reduce it by 3. Okay, because they know you were fooling with them. They don't like that. So don't play games with them. Just expect, if it's a short sale, you're going to have it cut by 1%.
Are the lawyers expected to reduce their
Of course not. You know, one of the things about being a lawyer that, you know, I mean, I don't charge anymore because I just work for First American Title. I just charge them. But I used to charge, last time I charged was $3.30 an hour, all right? You'd be amazed at how little of that $3.30 goes to the lawyer. To begin with, you charge $3.30 an hour. You actually only collect on average about $2.90, all right? Because you just know you're not going to collect that much. And so if a lender came to me and said, I want you to take a 10% hit, I'd go, yeah, that's fine. Just get me paid. Just get me paid. Most of the time, though, lawyers are smart enough to know not to put it on the closing statement. Okay? We know better than that. But we will sometimes take a hit. We don't like it either. They won't pay for some other things. They won't pay for home warranty plans. They won't pay for pest inspections. They won't pay for roof certifications. They won't pay for sewer inspections. They never pay for repairs. They're just not going to. Don't even ask. So why would a lender agree to do this? I talked about it before. The average cost to them is $60,000 if they foreclose. Look at the whole mortgage debt crisis we're in. It's because it's on their books, right? Getting this off of their books removes this crisis. That's kind of the concept of the government's first plan of just buying all these loans to get them off the books. So they've got some incentive to do that. They really don't want to own property. They sure as heck don't want to have to sell property in this market. So they've got some incentive to do a short sale. Even if they don't sound cooperative, they actually would rather do it. Why would a buyer do it? I have no idea why a buyer would buy on a short sale, all right? Seriously, the property is being purchased for the comparative market analysis. It's what it's worth. They're not getting a screaming deal, all right? At a foreclosure, they're likely to get a better deal than they are at a short sale. So I don't know why. It also takes a long time. They can't even apply for their loan until you get this approval from the lender for the short sale. I mean, if they sign an earnest money agreement and they run out and lock in a rate, okay, it's going to long expire before that 90 days when the lender says go. I mean, that happens. I get calls all the time. how do we get in touch with this lender? My lock's going to expire and they haven't approved the short sale. I'm like, apply for another loan because it's going to expire. Yeah.
I've seen a case where the borrower had moved out of the house, trying to negotiate a short sale before it went into foreclosure. But the borrower had taken the furnace out, the washer, one of the bathrooms, one of the toilets. I think the sink was gone, the counter was still there. Yeah, it was two bathrooms, but one of the toilets was gone.
Yeah, there are some issues. Now, you know, and it's not like the buyer's going to go after the seller for all this problem because the seller doesn't have any money or they wouldn't be doing a short sale in the first place. There's some risk in that. There's a lot less than that. Most short sales, you don't have that problem. Unlike a foreclosure, as you know, you're getting what you get. And if you got one of those toilets that's, before the old low flush thing, those are some value. Otherwise, you got to go to Canada to buy them. Anybody heard anybody going to Canada to buy a toilet that doesn't have the low flush thing? Because people do it. So, when they're editing things out of the tape, I hope it's the editing out the low flush toilet comments. All right. There are some alternatives. Here is another place where there's a possibility for the government to bail out this industry without having to buy all the loans. Okay? This doesn't happen very often, though, because the seller is burying their head in the sand and they're not helping. And you as a broker are not going to help them with this part, all right? But the ones who call the lender and say, I've got a problem, there's some alternatives to a short sale, and that's renegotiate your loan, right? Lenders don't want to foreclose. They don't even want a short sale. They make money by loaning out money and getting paid money back. That's their business. So they would actually like to renegotiate. The trouble is when there are some of these securitized loans where there's no opportunity to renegotiate. That's where you run into a problem. But if you've got a lender, it's always worth trying. And anyway, I'll mention the things that they might do. You can renegotiate the loan to add in the past due amounts over the entire term. All right, so your loan was $1,500 a month, and now when you add in the past payments, it's going up to $1,600 a month. Lenders would much prefer to do that. Obviously, it has to be someone who isn't broke yet, but they'll do it. Or a repayment plan to get current. All right, they still owe $1,500 a month, but for the next 6 months, they're going to pay an extra $100. Yeah.
I have a listing where the seller is not destitute, but the house next door, which is the same house, is selling on a short sale. Same exact house as this one. Do you think my seller would have any opportunity to renegotiate the terms of their mortgage just based on the fact that the short sales next door when my seller is not destitute, they're not behind in their payments?
Well, I actually don't want them to be able to, because that just doesn't seem right, does it? But no, they're probably not going to be able to, because they're going to want to see that there's some reason, some problem that they can't pay back their loan. That's the lenders, as long as they're getting paid, So unless they called the lender and lied to them about their financial status, then they're probably not going to be able to renegotiate it.
Do you think the lender also will not approve a short sale on this property because the borrower
Has money, has income? Yeah, certainly I've seen them denied for that. That's the reason why they're requesting their financials. If they see that you can pay, they're going to make you pay. And they ought to anyway, right? Anyway, get off the high horse. But they really ought to. It's hard to get off that horse sometimes. I would like to see, and I think it would be difficult, but wouldn't a government bailout be better where they took these distressed borrowers and came up with a way to bail them out without relieving their obligations, but still let them fix, maybe it's because it's a loan where the percentage is adjusting to an amount that they can't pay, all right? So the federal government steps in and says to the lender, don't raise the interest rate yet. We'll cover it in the meantime. And we take a tax lien against the individual. They're not getting out of their debt, all right? But it gives them some more time. And maybe they agree to forbear ever trying to get that lien against them for 5 years, or something like that. There are some other maybe they just pay and are done with it, although I hate to see that happen. But if we could renegotiate some of those debts. Now, talk about complicated, because how many loans are there out there that you'd have to be dealing with? But it might be a better way.
People can make applications.
Yes, absolutely.
for it, and then negotiate it down to the original amount the lender started them on.
And to the extent that we're having employment issues right now, we could hire a whole bunch of unemployed people to help deal with processing all these applications.
It pay for itself.
It's a lot like what we did during the Depression, isn't it? Thank goodness we're not there yet. Anybody think we're in a recession?
Yes.
Anybody think we're in a recession? Yeah? Any of you actually know we're in a recession? You'd be wrong if you know you're in a recession. Recession is 2 negative quarters of GDP. Guess what? Last quarter was a positive, okay? So even if this quarter is negative, we're still not in a recession. We can't be in a recession until January if this turns out to be a negative quarter, and we don't even know yet. So, find out. Now, granted, the real estate industry, the real estate industry is in a depression, all right? It's not even a recession. But technically, a recession is 2 negative quarters of GDP, and we're just not there yet. I'm not saying we aren't going to be, but we're not there yet. Yeah?
Did you say you were counsel for a hard money group? Is that what you said?
I've been counsel for a number of hard money lenders over the years.
When they calculate that number, do you know if they subtract the inflation rate from the growth to get whether you have real growth or not?
I don't know. We'll get an economist in here next time. Although they're pretty busy these days, aren't they? Economists are very busy at the moment. All right, so I mentioned earlier about getting the release of the lien or the release of the debt, and I want to stress that one more time before we stop talking about short sales, because it's terribly important that you that when you're applying, because you're going to be the ones applying to this lender, that the request is that you're requesting that they approve a short sale, that they release the lien against the property, and that they cancel the note. Okay? Because if you don't ask for that, they may not. Most lenders are not being so devious as to think they're sneaking around this and going after the borrowers later. They're just, because it's different departments, remember? Okay? There's a department that's holding that note, and they're getting paid on it, and say it's a $100,000 note, and they get paid $80,000, all right? They don't even know that there was a short sale. They just know they got paid $80,000, and next month, when there's another monthly payment due, there's 20 grand left on that, they go back and they get in touch with the seller and say, you need to pay me. You missed your payment.
That leaves us exposed.
Absolutely.
frankly, for a legal issue that we shouldn't have to deal with.
Yep, sure enough. So you know that this is in order of who practices law in the state of Oregon, okay? This is the order of who practices the most law. Brokers, escrow officers, lawyers. Seriously. Absolutely. You're practicing law all the time. And the real risk is your E&O coverage doesn't cover practicing law. So if you get sued for practicing law poorly, you don't have insurance for it, most of you. So, but you do practice law. That's just part of the deal. We couldn't survive. People can't hire lawyers to help with all these residential transactions. First of all, there aren't that many lawyers. Imagine that. That'd be really bad, that many lawyers. But they also can't afford it. So,
Most lawyers get involved and the deal goes south.
yeah.
It's the truth.
Yeah. You know, in my deals, it's always the front end, because I'm not a dispute lawyer. Yeah.
What was the whole concept of assumable loans? And if you had a buyer that was willing to assume a loan on a short sale, is that even a possibility?
You know, it's funny because I got that question yesterday, and it's the second time I've ever had that question when I talk about short sales. Most loans used to be assumable way back when because lending wasn't as sophisticated as it is now, right? Despite how bad the market is, it is a very sophisticated market at this point. Loans are assumable unless they say they're not, right? It's signable is what you're really talking about, but they're going to be assumed by the party. They are assignable unless they say they're not assignable. If you get a Stevens Nest trust deed form, right, there's two forms. There's assignable and not assignable. And lenders do, when lenders loan money, there are two, anybody here a lender? Somebody here's a lender, isn't there? Nobody here's a lender? Okay. Two things. I'm not going to say anything bad about lenders. Well, I might. Two things. They want to get repaid, okay? That is the most important thing. They want to get repaid, which means they want their borrower to be able to repay them. They want to see their financials. They want to see their history. They want to know they're going to get paid. Second, if they stop being paid, they want to be able to realize on the security. That's the value of the property and having a trust deed attached to it. Very much in that order. Okay? I don't care how good the property is. They're not going to make the loan if they don't think they're going to get repaid. So, when you're making a loan and it's assignable, then who are you making the loan to? How do you know you're going to get repaid? Usually there's some provisions for approving, but you know, it's kind of wishy-washy in most of these small loans. So as the nature of the industry became more sophisticated, they realized the most important thing was being paid by this borrower, and so they made them not assignable, which means they're not assumable. Commercial transactions are where I still see the most assumable loans because they're not packaged up the same way as residential loans. And I've done a number of loan assumptions over the years, and rarely is it worth it. The reason why we do them is because there's some reason that the lender doesn't want to get paid. They want to keep that loan on their books, so they'd rather it be assumed. But what they make the new borrower go through is no less than what they made the first borrower go through, which is making sure they can get repaid. So essentially, it's a new loan anyway. Well, why not just do a new loan? So that's pretty much why they got away from that. The other is they package up these loans. Right? You all know the whole reason why we're in this mess is they package up loans and they sell them. They can only package them up and sell them if they're all exactly the same. Exactly the same. Every borrower has to have exactly the same financial credit score or whatever in this package, right? You know, you've got a group of credit scores in this package, and you've got some other groups that are this package, and this package is worth less because they have a lower credit score, all right? And so if you made them assignable, then they may not fall into that package. So they just said, no, we're not going to make any of them assignable. Anybody here ever done a conduit loan? Anybody here heard of a conduit loan?
You talking about RAP?
No, no. Conduit loan is a lender, these securitized loans, where because the investors are putting in, they're getting a fixed rate return, it's actually going to be less than most lenders. Okay, so they're great deals for commercial transactions. Therefore, say a 10-year period and you cannot repay them. Okay, you just can't do it because they want to get this fixed return. And the interest rate is generally lower than most loans. All right, they're usually non-recourse, which means the borrower isn't going to be personally liable. All right, so they're great loans to get. They cost a fair chunk of change to get, but usually not a whole lot more in the end. If you go over the whole 10-year period, it actually winds up being less, but you pay a little more up front for them. Tons of legal fees, unbelievable legal fees in them. But you can't negotiate a single term. Nothing can be negotiated. I mean nothing, because they're going to package it up and sell it because they're all going to have exactly the same terms. You can't change a single word in the trust deed, even if the change would be irrelevant, because it's part of the securitized package that's going to get sold around as shares. So having them be assumable would be very, very difficult in the present market that we have. It would completely change the way loans are packaged and sold. So it's not going to happen. Maybe that's another way to deal with bailouts, though. We pay for loan assumptions.
Is there an advantage to making the deal come together if the new buyer also applies for a loan at the same financial institution as, no? Okay.
No, not going to make any difference. Different groups,
Yeah.
completely different groups. Yeah.
She's talking, could you wrap it? My question, could you like to wrap the second?
You can't wrap any of these securitized loans. There's no approval process that you can get. Wrap, has anybody dealt a wrap, done a wrap? A wrap is where you have an existing trust deed, okay? And so you got a new buyer who is, the seller is still going to be obligated on that existing loan. It's not going to go away. And so the new buyer is going to pay to the seller or to an escrow account, and then part of the money is going to go to pay off that existing loan, and then part of it's going to go to the seller each month. And that's basically what a wrap is. A little more complicated than that, but that's essentially what they are. And you could never get the approval for a wrap because all these loans that are securitized all have a due on sale clause in them. It says there's a default if you assign any interest in this property. And there's generally no approval process you're going to get from a securitized lender because you got 20,000 shareholders and some, so it's not really something that you can get approved. Most wraps are either done as hard money loans, where the first is a hard money and so they'll approve it, or where the parties are not going to tell the lender that they're doing a wrap, okay? That's most of them. When I dealt with wraps, always advised my client, you need to get the consent of your lender to do this wrap. Whether you know, two things when I give advice. Two things are important. One, that I give good advice, and second, that I get paid for it, right? After that, I don't care if they follow it. So I'd send a letter saying you need to make sure you get the approval of your existing lender before you sell this property and do a wrap. Whether they do or they don't, that's up to them, okay? The way they get caught, though, I'll tell you this, is when they sell the property, they cancel their insurance, all right? The new buyer gets insurance. Well, their lender gets a notice that the insurance has been canceled, and that's how they find out about most of these, when they don't bother to get the consent. Yeah?
So is that mortgage fraud or is that just default?
Well,
Someone does the wrap without notifying the lender?
if there's no loss, then probably not.
But you can also just call a lending officer and ask them if they say, okay, go ahead. Or are you talking about getting?
No, you have to get a written consent to do a wrap from the lender. Calling anybody, I mean, let's say you got your loan from Wells Fargo and you go to the local branch and say, hey, I want to do this wrap. Do you mind that? No, go ahead. Not in a million years do they have authority to do that. You're just in default, just as much in default, even though you got the consent of some local folks to do it. Yeah?
I think the VA still issues mortgages rather than trustees and notes. Is there any difference in negotiating a short sale where a mortgage is involved as opposed to a trustee note?
I can answer that two ways. One is I doubt there is any, but I have never seen anybody negotiate on a mortgage. But I'm sorry?
I never have either.
There are so few mortgages these days. I mean, there just really are very few, which we'll talk about foreclosures here in just a second. And you'll understand why there are so few mortgages these days. Was there another hand back there?
I was going to ask on short sales. Number one, do they have to be disclosed on the MLS that it is a short sale? Or
I think you should.
Okay.
I think you should disclose everything.
Right.
But it starts with the whole idea that I think you should disclose everything.
Well, if they're not, is that, I've seen them not, how's that?
Well, but sometimes actually people don't even know they're going to be a short sale when they list it. Okay? That's a perfectly good excuse. But I think you absolutely should, because when you do this short sale, when you list this property and then you get a buyer come up, you're going to use the short sale addendum. It's not like you're hiding anything from them. I mean, they're going to know all about it. And there are some buyers who actually think, ooh, short sale, I'm going to get a better deal. Okay? Because the seller doesn't care what it sells for at that point, right? So, I mean, you know.
And can it be approved before there is a buyer?
As a general rule, you're never going to get a short sale approved without there being a signed earnest money agreement. Remember, as I went... I'm sorry?
The reason is that on the MLS it says already approved short sale.
Yeah, you know, it depends on who that lender is. Remember I said you're going to see differences in how these work, but I've not seen that, and I would be surprised about it. Yes, the lender may have been contacted to say, yes, we're going to do a short sale, but they're going to want to know all of the terms of it, all of them. I mean, if it turns out they're selling it to their brother for a fraction of what it's worth, it's not going to get approved.
So if it was approved and it fell through, say somebody backed out, the buyer backed out,
Figure another 90 days.
well, is it approved still?
No,
Okay.
no, because they're only going to approve that sale. So that sale's going to be there. Yeah?
Okay, here's a case that's going on right now. There are 4 approved offers on a short sale property, and the service company is negotiating the lender, and those may be held 90 days before one of those 4 people is going to get the house. But they approve them all. Counter offers are signed, everything's signed, but the service company and the lender are sitting on it.
Mm-hmm.
So they can be approved, but that doesn't mean anything.
They haven't actually approved the sale. Well, have you ever seen a loan app that says, yes, we say we're going to loan you, up to $200,000? Well, they don't have to loan them anything,
No,
right?
I'm just talking about,
Yeah.
we have a signed counter offer with whole process.
And it's still not done.
And they're holding 4 approved
Yep.
offers.
Mm-hmm.
They're turning in approvals.
Yep, that's exactly right. They're treating them like pre-approvals. Anybody have any more short sale questions? And then we're going to take a break and let y'all use the restroom. Any more short sale questions? Okay. Come back in 5 minutes. Now that everybody's sitting in quiet again, Anybody gotten one of these letters in the mail? This one came to me because I live in Portland, but it says, Portland hit with more than 7,800 foreclosures. Anybody gotten any of these sort of letters in the mail? It's about a class, okay? And it says, a recession is a gateway to enormous real estate riches. I read that and I went, they immediately lost credibility with me because I'm like, well, that's fine, but we're not in a recession yet, so where are you getting this from? You know, don't let uncertainty or lack of money stop you from taking advantage of today's real estate meltdown bargains. It's, I went to this. It was free for the first day. It's a 3-day class. You go for the first day. It's free. They're going to tell you all about how to make $500,000 in equity, or Claudia Keyworth made $165,000 in 3 months, or Lee Walters made $58,000 in 1 month. It's a load of crap, by the way. So I went to this 1-hour class, and I didn't tell them I was in the industry. I just told them my name, you know, and you wear a little name badge around. You sit there, and some guy from Arizona, and he's up there talking to a room about this size, about this full. Folks were either retired or looked like they hadn't worked in a long time. They were sitting there. And he's, yeah, kind of like this group. Yeah. And I like that. I'm glad I didn't say that first. I wasn't even thinking it, but it was funny. So. Yeah, these folks, they were probably making money because they were unemployed. But anyway, so I sat through this class all day, and they talked about how they're going to help you make a fortune on foreclosures. And technically, what they were describing works. Okay, that's why they can do this, is they weren't lying to anybody about how it was going to work. They were certainly misleading, in my opinion, but they weren't lying. Technically, it worked. Practically, not so much. Okay, zero down, make $1 million. All right, it's just pretty hard to do. And there are a couple people who managed to do it, although I think most of the time they're fraudulent. They were describing how they compile a list of properties that are in default based on the notices of default that are recorded, which, as a title insurance company, we're actually the ones that keep track of those, and they get them from us. And they were selling this list. That's the first thing they were doing that was smart. So you could buy this list from them, and then you'd contact these people that are in foreclosure and say, you're going to lose your house anyway. I'm going to give you $1,000 to give me the letter of authorization to negotiate this for you. Sell me your property. $1,000. You're going to walk away from nothing if this goes to foreclosure. I'll give you $1,000, and that $1,000 you can use to put down as a security deposit for your apartment where you're going to be living from now on, because you're going to lose your house. And people take that. Okay. Now, unfortunately, most of the time, the ones that I've been personally involved in that I've seen come through my office, and by the way, we will not close these transactions. Is it's usually a Russian family or a Hispanic family. They don't speak English. They've got this loan. They're in default. They know they're going to lose their house. You bet they're going to take $1,000. And you bet they have no idea what the ramifications are of doing this. But they're going to do it. And somebody's scamming them. So they take this $1,000. The broker negotiates with the lender. They get a short sale approved to themselves. Okay. There's the fraud right there, but nevertheless. And then the idea is that they're going to turn around and flip it for more money, all right? These are going to be harder to do now because it's just harder to flip properties. But they're still trying to do them, and they're still taking advantage of people doing it. And they say you're going to make a lot of money on these flips, or you're going to get a great house for yourself and you're going to live in it. And the reason why these people teach these classes, a couple things, is you can come back for the second and third day, but you got to pay $3,000 for that. All right, but hey, it's no big deal. You're going to make $58,000 in the first month, so what's another $3,000? The real way these folks are making money isn't from charging $3,000. Is they're actually making the loans to these people to buy these properties. Okay, they're a hard money lender, and they're charging a lot to make these loans because these folks can't go out and get the loans otherwise. I mean, right now, where are you going to go get a loan on some of these investment properties? So they're making these hard money loans. And then either they're going to make a bunch of money on the loan or they're going to foreclose on it themselves, and they're going to make some money on that. So it's quite an interesting scam. But technically, it all works. So I've just pretty much summed up the first day of that class, and if you want to go to more, just pay the $3,000 and go to the second and third day. But it's very interesting. There are people who make money on foreclosures. I mean, I'm sure some of you have bought houses at foreclosures because you're knowledgeable, you're in the industry, you know what the properties are worth. You see what's coming up for sale. But the scam that some people are doing is not one that I recommend. And when I see, you know, the worst part about it is most of the folks who are doing these scams are brokers. Okay, that's the downside. I mean, there's some bad lawyers out there, right? There's some bad car salesmen out there. Unfortunately, there's some bad brokers out there too. And when we get one of these brokers who sends us over one of these deals where they're negotiating the short sale and the Russian family's getting $1,000 and, you know, they don't know anything about it, I'm like, no. And then I add that broker to a list of people that, you know, we're not helping with anything because they're crooked, and there's a few out there. So watch out for those folks. And then I also turn them into the real estate industry, and they're usually having them sign documents that are legal documents that they're preparing or printing off their system, which is practicing law, and I turn them into the Bar Association as well because they're scamming folks, and I don't want, you know, I mean, I hate to see these people who can't even speak English get their properties taken away from them. Some guy's going to make a bunch of money. Yeah.
So when you get contacted by somebody, like a private person who's trying to pull something like this, is that the best thing is to turn them into?
The Attorney General, the Real Estate Division, the Bar Association, whoever you can think of that might go after it. I mean, I don't like to see people get out of debts. I also don't like people scam folks out of things either. So.
I was contacted by someone trying to do that.
Yeah. Turn them into the Attorney General.
I got as much information from them as I could of what they were planning on doing.
Pass it on. I mean, it depends on how busy the AG and, you know, again, you get to mortgage fraud right now, boy, that's high on everybody's list. I mean, that's just an easy one. They're going to grab that and run with it. So see what you can do on it. We're going to talk about foreclosures a little bit. This is a lien theory state. I'll mention that a few times. It doesn't actually matter. But there are two types of states as far as securing an obligation on property. There are title theory states and lien theory states. In a title theory state, the lender has title to the property, not just a lien. In Oregon, it's just a lien. It's not title. I mention that because if you go back to the oldest form of securing a piece of property, and people still do this, and by the way, it doesn't work. Okay? So I don't want to see any of you do this. Here's the deal. You're going to lend me $10,000, which is great because brokers are making so much money these days that you've got money laying around. So you're going to lend me $10,000. And to secure this loan, I'm going to give you the deed to my property. Okay? And you're either going to record it now, and then when I paid you back, you're going to deed it back to me, or you're going to hold that deed until I'm paid, and if I don't pay you, you'll just record it and then you'll own the property. Okay? Sounds great, doesn't it? Sounds really simple, sounds really easy, and it absolutely does not work. Because we think that, well, and traditionally this was certainly true, that lenders are more sophisticated than borrowers. Lenders generally will take advantage of a borrower if they get the opportunity. Certainly people have. There are lots of rules that you have to follow, not because you're going to steal your client's money, you know, because of their earnest money or whatever, but because some people have, so they apply it to everybody. Well, there's some lenders that are like that as well. So if I give you that deed to my property and you record it, you don't have title to my property because this is a lien theory state. You only have a lien because I didn't deed you the property as a sale, it was just as a loan. So it's a lien theory state. Because you did something that we don't like as a public policy, we're going to penalize you for having done that. I say it's for having done something stupid. It's really just ignorant because the people who generally do it are ignorant of how the law works. They think that deed will work just fine, and it doesn't. What we make them do is go through judicial foreclosure, the hardest possible way to get the property in your name as a lender is judicial foreclosure. It's the most expensive, it's the most time-consuming, it's the only way under a mortgage that you can foreclose on a piece of property. So we treat that deed as if it was a mortgage. And by the way, that deed doesn't have an attorney's fees provision in it, doesn't have any of the, you know, mortgages are multiple pages long for a reason because there's things that need to be there. And that deed doesn't have it. So you're going to get penalized even more for having done it. Once a week, I get presented with a deed to this day as a loan, security for a loan, and it doesn't work. So don't do it. It's even worse when I see lenders who make a loan. This only works on hard money loans because commercial lenders know not to do this. At the time they make the loan, they make the borrower sign a deed in lieu of foreclosure and say, if you stop paying, I'm just going to record the deed in lieu of foreclosure. Guess what? Nothing happened. Okay? It's a lien theory state. Title didn't transfer. Sorry? Lien theory state. Yeah, it's just a legal term of art. wouldn't even write it down. But it means that you don't have title. Even though you recorded that deed in lieu of foreclosure, it only works if it's given after the foreclosure, after they're in default. Okay? You know what a deed in lieu of foreclosure is, right? The lender starts a foreclosure, the borrower says, gosh, I can't pay, I'll just deed it to you. And so they deed them, and it's called a deed in lieu of foreclosure. And if they sign it at the time they signed the mortgage, then it didn't do anything. I actually think it makes things worse. And there are developers out there who are selling properties where they're doing the seller financing, and they're having the buyer, sign a deed in lieu at the same time they sign the trust deed. And when they don't pay, they go and they just record it. And I'm like, that was nice. Now, would you like to go through a foreclosure? And not just a foreclosure, now you have to go through a judicial foreclosure. Even though you had a trust deed out there, now you've mucked it up. Okay? Shouldn't have done that. So, this is how foreclosures work for mortgages. It's judicial foreclosure, one of the reasons why you don't see very many of them anymore. The lender has to sue the borrower, and it goes to circuit court. We all know how long it takes to go to court. Basically, to do a judicial foreclosure, it takes about a year. Okay? That's a really hard way to get your property, because you're not getting paid anything during that time. So you sue them in circuit court, and the court will then order the sheriff to sell the property. So the sheriff is the one who's going to go out there and sell it. Up to the time of the sale, the debtor has the ability to pay it and stop the sale. But they have to pay the whole amount. They can't just come current on the mortgage. They have to pay the whole thing off to stop the sale. But they can do it right up to the moment of sale. They can show up the day before and hand them a check for $180,000 if it was a $180,000 loan, and then it's stopped and it's done. So that's basically how it works. There is 180 days after the sale that the debtor can come back and pay the amount of the mortgage plus some costs and fees and get their property back. So, as you can guess, any buyer isn't going to get to touch the property for 180 days, right? They're not going to pay much for that property because they might come up with the money to buy this property. They can't go use it. They can't touch it. Within 180 days, they may have to lose their right to it. They'll get paid back, but they're not going to get to keep that property. So people pay pennies on the dollar at a judicial foreclosure for properties. So that whole thing takes a year. Now, the advantage to a lender is they can actually seek a deficiency judgment. It's the one time they can, all right? If the sale, it's a $200,000 loan, and somebody only pays $150,000 for it at that foreclosure sale, then the lender can still go after the other $50,000 against the borrower. Only on a mortgage, when you do a judicial foreclosure, can you get a deficiency. Under trust deeds in Oregon, no deficiency judgments. So that's a mortgage. That's why people don't use them very often. Trust deeds are custom and practice in Oregon for financing. They weren't until, I think, about 1962. What happened is, after World War II, California had a big boom. You might have noticed back then, if you read history much, that there were a lot of ports, there was a lot of industry that went into California during World War II. It pretty much made California what it is today, to some extent, not counting Silicon Valley and things like that. But for the World War II stuff, it would not have been the same. Well, lenders wanted to make loans. Okay, let's start with this. The whole reason why we're spending days talking about this mortgage crisis is the banks have one of the strongest lobbies in the world. They have basically stopped Congress from doing anything but talking about them right now. That's how big their lobby is. They want to get bailed out. They really want to get bailed out. Well, they had a pretty big lobby after World War II as well, and they went to the California legislature and said, you know, foreclosing on a mortgage is really a hassle. We'd like you to pass trust deed laws so that we can go through non-judicial foreclosure. So California did. And lenders stopped making loans in Oregon. They started making all their loans in California because it was easier to get their money back afterwards. So Oregon went, well, I guess this is a problem, and they took about 10 years to pass the law to create trust deeds. So we have those in Oregon now, and under a trust deed, instead of just having a mortgage, you have a note and a deed of trust. We talked about that earlier. Well, when they stop paying, you can go through judicial foreclosure if you want under a trust deed, and there are times when you'd want to. One of the reasons I mentioned before is under a mortgage, when they're in default, it can only be cured by paying the whole thing back, right? In a trust deed foreclosure, on a non-judicial foreclosure, they can just come current, right? They don't have to pay the whole thing back. They can just come current plus some costs and fees, and then it's reinstated again during that, if it hasn't gone to sale yet. So there's some advantages to doing a judicial foreclosure occasionally, not very often. I've got 2 judicial foreclosures going on right now in trust deeds because only the husband signed the trust deed. That's a defect in the trust deed. And we can't foreclose out the wife's interest without trying to go through judicial foreclosure. It's expensive and it's time consuming, but it's what we have to do because we have 2 bad debts. That's having a debt on the books that's a tough one. We actually own those loans because the lender made the loan, we insured the loan, only the husband signed, later found out there was a wife, somehow that got missed, and the lender couldn't sell that loan because it's not going to fit in the box now. So we actually had to buy those loans. And the borrower found out there was a defect and said, well, I'm just not going to pay. And we're like, well, that's nice. We're just going to sue you then. So, and we will get our money out of them. Under a non-judicial foreclosure, what you do is you record a notice of default, statutory form. It lists what needs to be put into it. 120 days from the notice of sale is when there'll be a sale. Usually add in a couple of weeks. So you're talking really about, 140 days, I usually figure. But 120 is all that needs to be there. The sale happens between 9 and 4, either on the courthouse steps or the office of the trustee. The notice of sale has to be served on the occupants of the property. This is a change in the law. It's fairly recent. Has to be served on the occupants of the property. And if it can't be served, it has to be posted. As you know, there's publication as well in a newspaper of general circulation. Sale can be postponed to allow for sufficient time to give notice to all the parties. Sometimes it gets postponed because there's a stay because the borrower filed bankruptcy, which stops the foreclosure. Otherwise, the lender can do it for any other reason, the chance that it might actually go through as a short sale. Postponements can't be more than 180 days from the original date of the sale. The sale itself is pretty interesting. Anybody been to a foreclosure sale?
You can't find them.
Technically you can, but it's not all that easy. I've done a couple myself. It's kind of fun. Getting paid $330 an hour to stand there and read. Standing on the courthouse steps, you have to read the whole thing. Okay, you have to read the sale. So at 10 in the morning, standing on the courthouse steps, and I'm reading the whole thing. Anybody been to Pioneer Square in Portland? There's always somebody out there espousing some religious stuff to nobody who's listening, all right? They're going on and on and on about either doom or savior, I don't know which, but they're always going on, and nobody's actually listening to them. I kind of felt like that. I'm standing at the courthouse steps, and I'm talking to no one, all right? And I have to do it out loud, and I have to read the whole thing. And one of them had like a 2-page legal description, and I have to read the whole 2-page legal description to no one, okay? Just standing there in my suit, getting paid to read a legal. I'm on the courthouse steps. The court's going on during this time, so people are going in and out of the courthouse the whole time, and they're watching me read a legal description to no one. I'm like, what is that loon doing? But that's how it works. And nobody was there to buy the property, and so the lender took it for whatever the debt was. Anybody junior to them was foreclosed out. Okay. Sometimes people actually show up at these sales and buy, occasionally. They can pay either by cash, which is rare, and a hassle because a suitcase of cash is both heavy and risky. Never seen it happen. Although I have seen people come into closing. I had a guy buy a house once for $300,000 and some odd with cash. Such a hassle. My favorite client, though, flew into town one day to buy a house. He's from California. He was tired of paying taxes down there. He wanted to buy a house in the state of Washington. He flew into town. Said he wanted a house on the river, showed him 2 or 3 houses, and he says, yeah, I'll take that one. That day, wrote a check for like $1.8 million and wanted to have the keys. And we're like, okay, this is great. I'm glad you could write a check for $1.8 million, but the check has to clear before you can have the keys. Because he wanted, the sooner he started having that as his house, the sooner he was not paying California income tax. So those 3 days were costing him some money. He's like, well, I'm rich. I'm like, that's nice. The check still has to clear. So anyway, it's a great client. Sometimes people will show up and buy. And the easiest way they do it is they bring a bunch of cashier's checks, usually in $10,000 increments. And they can talk to the seller ahead of time, the trustee who's selling the property, and say, if it's over this amount, then, I would like to get my money refunded, the balance different when you give me the deed, which is usually what happens. I mean, they want to get the money. The trustees are going to make this happen as easily as possible. So usually they just have $10,000 increments in checks. Sometimes they'll have 2 checks of $100,000 each and then $10,000 after that because they know they're going to pay at least $200,000 for it, if that's what the loan is. So that's usually how it works, and they just fill in who the party is that he gets paid to at the time of the closing, because they're usually running around to different sales doing these. So that's basically how it works. Within 10 days, they're going to get a deed to the property, and within 10 days from the sale, they can kick out the occupants of the property. It's as if they're a tenant who isn't paying. So that's how soon the borrower has to get out. The borrower has no right of redemption after the sale. Okay? In fact, up to 5 days before the sale, that's when their right to stop it ends. They can't pay up. So afterwards, there's not that 120 days of right of redemption, which makes trust deed sales go for more value than a mortgage sale would normally. Briefly talk about real estate contracts. Real estate contracts allow for forfeiture. They also allow for judicial foreclosure and non-judicial foreclosure, but they have a third remedy that the lender can use, and that's forfeiture. Real estate contracts, same as a land sale contract. A real estate contract is a better term because it applies to property that has also been built. Land sale contract tries to suggest that it's bare land. Traditionally, that's all they were used for because people could get conventional financing for a built property, and it was harder to get it on unbuilt property, unimproved property. So real estate contracts are seller financing. Basically, the seller is the lender. And under those, when the borrower stops paying, they give them a notice that tells them that they have 60, depending on how much equity they have in the property, either 60 or 120 days to cure. Okay? The idea between the different time frames is if they've mostly paid it off, then we don't want them to lose it in just 60 days. So depending on how much equity, depends on how much time they have. It's far and away the quickest and cheapest way to get the property back. And there's no sale because what happens is the contract is forfeited. It just disappears as if it was never there. So any payments that have made along the way, the seller just gets to keep those. So that's kind of the basic idea of them. The idea of the payments being kept is kind of considered liquidated damages. The reason why you don't have to have a sale or anything like that is under a real estate contract, title to the property stayed in the seller. They had legal title. They never transferred that. All the buyer has is what we call equitable title, and that gets extinguished by the forfeiture. So the seller was always in title, so they stay in title. So that's basically how that works. Anybody have any questions about that before I move on? Because I want to talk about my favorite class, and I need one of the outlines for it. If you turn to this outline that says Fundamentals of Transfers of Title, I talk about this one because, like I said, it's my favorite. I think it's the most practical. It's certainly the most useful. It's also the most entertaining. Turn to the second page. It's my little gimmick for the day. See the squares? How many squares do you see? Keep going. Keep going. There's a lot. I'm going to tell you, there are 30 squares there. If you look at the top left-hand corner and you take the top 4 corners, those 4 make a square. Go to the next ones over. Those make a square. The middle 4 make a square. So there's 30 squares you can identify in that. It's a silly little gimmick, but it very much explains what people see when they see a deed. I hand you a deed. You see them all the time. Okay? You see the title of the deed says statutory warranty deed. You see that there are names of the parties on there. You see what the amount of the consideration is. You see that they've signed it. There's a legal description. There's a notary block. Okay? You've now seen 16 squares. You've missed the other 14. They all matter. Every square matters in there. It makes a square. So the idea of this is to talk about what those other 14 squares are when you're only seeing the 16. And I think it's the most practical part of what you do because you see deeds all the time. And always people are just seeing the 14 squares. So to go through that, I talk about the estates in land, the concurrent estates, and kind of the basis so that when you look at it, you'll know why these other things are there. Anybody heard of the analogy, a bundle of sticks?
Yes.
Yes? All of you? Lots of you? Okay. It's the first thing they teach us in first year property law is the bundle of sticks. That's what ownership of property is like. And I could picture it perfectly because I'd gone to school in Kenya. And every morning I'd see women walking down the street with a bundle of sticks on their shoulder. Because they don't have, most people in Kenya don't have electricity, certainly don't have natural gas, they don't have any way to cook their food. There isn't enough timber out there to make fires all the time. So what they do is they go around and every morning they collect sticks and they make charcoal out of those sticks. And that's how they cook their food. So I just picture this woman with a bundle of sticks on her shoulder. And if you own fee simple absolute, okay, you own the entire bundle of sticks. All right, that's owning the whole property. All the rights in the property are yours. You own the whole bundle. So if you give a power line easement to the power company, you are essentially taking out a stick and handing it to the power company. You still own the rest of those sticks, but they own that other one. It's not yours anymore. That gives them the right to run a power line across the front of your property. So your neighbor wants to put a driveway across your property to get to theirs. You grant them an easement. You're granting them a stick. You take a stick out of the bundle, you hand it to them. It's now their stick. That stick gives them the right to lay down gravel, to drive across your property, you know, to maintain it, whatever the case may be. A lease...
Does it have to be notarized?
Yes, it absolutely does. All conveyances, all transfers of sticks in Oregon. Seriously, though. The statute of frauds requires that they be in writing and to be recorded and to be constructive notice on another party, they have to be notarized. So you hand a stick to your neighbor. Well, if you're going to do a lease, that's also a stick. It's a different shaped stick. I think it's a very short stick, but it's a big one as well. Because when you hand somebody a lease, they have the right to possession of the property, even to exclude you. They have the right to operate on the property and make money on it, to use it wholly as their own for a certain period of time. But it's a short stick because at the end of 5 years or 10 years or 30 years, that stick goes from them right back into your bundle again, and it's yours again. But the whole time they were leasing that property, you still owned fee simple to the property. Okay, so that's the idea. Now, under fee simple, there's certain elements of it. First of all, it's of infinite duration. Okay, infinite duration. Lawyers used to get paid by the word. I'm not kidding. So when you'd see deeds, they'd have all kinds of extra words in them that really, herewith and therewith, and all those extra words. They were just getting paid more money for that. So when we say infinite duration, it's a way for lawyers to get paid twice as much than if we just said forever. That's all it is. It just means forever. So when you own fee simple absolute, you own that property forever. It's also freely alienable. Another thing that lawyers do is we use words that other people don't understand, because if you did, you wouldn't have to hire us. Freely alienable just means you can sell it. That's all it means. So if you own fee simple, you can sell your interest. It's inheritable. Okay, that one everybody already knows. You have the right of possession. You have the right to profits. It means if there's rents, you get to keep them. If there's hay, you can hay it and sell it for money. If it's got timber, you can harvest it and sell that for money as well. It's divisible. Divisible just means you can mortgage it out to a lender. It means you can borrow money against that property, pledge it as security for the loan. That's all divisible means. Whenever you transfer property, it is presumed that you transferred fee simple. Okay? If you don't say anything, the presumption is you transferred the bundle of sticks. So that's why when we grant an easement, we say it's an easement, because that rebuts the presumption of handing the whole bundle and just says, I'm only giving a stick. So all deeds presume that they're for fee simple. The next deed down, in lesser interest than that, I describe, is a life estate. When you transfer property by a life estate, you're only giving someone some of the sticks. Okay? It's not the whole bundle anymore. To make the presumption that it's not the whole bundle, we use other language. So what's your name? I can't see your... Jane. Jane, I'm going to pick on you now. No. Use you as an example. So if I'm going to sell you my property as a life estate, okay, just the life estate, then it's going to say, to Jane for and during her natural life. Okay? That language means it's a life estate. Okay? I could have said to Jane a life estate, but I wouldn't have gotten paid for as many words. And I don't know why we say natural life, because I always wonder, well, what's an unnatural life? I think it's just getting paid for another word. But that's what it means. So it would be to Jane for and during her natural life would create a life estate. So the elements of a life estate are, the most obvious one is the duration is limited. It's limited to the length of time that she's alive. Okay? Has nothing to do with her occupying the property. If I sell her a house and give her a life estate only, Okay, she doesn't have to live in it. She can rent it out if she wants. All right, it's for her life, not for her use. So, which is is a distinction that I get questioned about all the time. People say, well, you know, my stepmother has the property as a life estate, but she's moved into a nursing home, so is it mine now? And I'm like, well, she's still alive, right? Yeah, well, then it's still hers. She doesn't have to live in it. They have the right of possession. It's not inheritable. Sounds obvious, but I want to make that distinction between the other one. When they die, their interest is gone. Okay? The sticks go back into the bundle. Whoever still has the rest of those sticks, it's called the remainder of the sticks. That life estate terminates, and the interest that life estate were go back into the bundle. But they do at the time get the profits from the property, so you can rent it out, you can harvest the timber, you can cut the hay, whatever the case may be. It's also divisible. You can mortgage it. Now, I've only done a couple of mortgages on life estates, and they were hard money loans because you can't go down to Wells Fargo and say, I'd like to borrow money on my life estate, because they're going to go on your what? Because they're just not something that you deal with. And it sounds like, well, how could you borrow money on a life estate? Because when they die, the interest goes away, and how would you collect on that? It's really quite simple. You get a life insurance policy for the amount of the loan, so that if the person dies, the loan still gets repaid. So it works fairly well. Haven't done them too very often. They're created two different ways. They're either created by grant. In other words, I grant Jane a life estate, so then she has a life estate. I retain all the rest of the sticks. Or it can be created by me selling Jane my property, but retaining or reserving to myself a life estate. So she gets all the sticks but the ones that are a life estate. And I get to live there for the rest of my life. It's not a bad way to do it. I've had a couple of developers who really wanted to buy a piece of property their properties to develop them, but the nice old ladies who lived on the property said, oh, well, I plan to live here the rest of my life. After that, I don't really care. Okay? I'll happily take some money now, but I want to live here the rest of my life. And so these developers bought these properties. They didn't buy all of it. The seller retained a life estate. And when she dies, these developers get the property. It might be 2 years, it might be 20 years. And then they'll get to develop it. It's safer than an earnest money agreement. I have never read an earnest money agreement that I couldn't break. Okay? So if you're going to invest in a piece of property and you really want to get it some years down the road, an earnest money agreement is really not the safest way to do it. An option is better, but I think the most litigated document in real estate transactions is an option. So that doesn't seem like a very good one for some deals. A life estate, while it costs them more money to acquire, was a much safer way to acquire their interest in that property. Someday, if you have me back, I can go through all the lists. I have this class called Tying Up the Property. It's all the different ways you can tie up property. And most people don't think about tying it up through a life estate, but you can. The next thing I'll talk about are illegal conditions. These are a lesser interest. There are some things that we address on property that we consider against public policy. It just means we don't like them. Right? We've determined that it's not good for the public, so we won't allow them. Partial restrictions on ownership of property, though, are generally okay as long as they're reasonable. And you've all seen different types of restrictions. As you already know, you're not allowed to restrict ownership of property based on color, race, religion, national origin, or handicap. Okay? Those are they just don't exist as far as we're concerned. You can't do it. I don't know if you have any neighborhoods in this town, but we have plenty of them in Portland up through the 40s and 50s. People would create a neighborhood, they'd subdivide some property in Portland, and they'd say, nobody can live in this town, in this neighborhood if you're black. You can't own this property if you're black. Okay? There's lots of subdivisions in Portland that say that. I'm from Camas. There was a law in Camas that said you couldn't be black after sunset in this town. You sure couldn't own property. Anywhere in the city of Camas, you could not own property. Okay? That was in the deed records. Yeah, no. It's a nice thought. And we obviously came to the conclusion that that was a dumb rule, right? Okay? Did I oversimplify it a bit? But those things are still in the deed records. We can't go through with an eraser and take them out. So what we did is we passed laws that says those are illegal conditions. They're not allowed, all right? Those are some obvious ones. There's some other ones that are a little less obvious, and this is one of my favorite ones. When people, historically, you'd get say you had a man who had property. He'd had a wife who died maybe, and he had a couple of kids with her, and so he's got some children, and then he remarries, right? And when he dies, the property's his, it's not his wife's. So when he dies, he, wants his wife to have the house to live in. But this has come up quite a bit in deeds. I've seen this many times. The deed to his wife says you can live in it, but you can never marry, okay? Because he doesn't want some new guy living in his house, all right? That's an illegal condition because we want to encourage marriage, at least amongst certain people, if you're of certain sexes. All right? But generally, we want to encourage marriage. Those of you who don't like gay marriage, and I'm not saying whether I like it or not, I'm saying get used to it because it's part of the deal. It's just like in the 50s when they said, well, you know, we don't like this thing about you can't be black and live in the neighborhood, so we're going to get rid of it. Well, we've changed this other thing too. So start getting used to the idea. And I've been telling this to people for years. Get used to these things that you don't otherwise like because they're coming along. It's part of the deal. You know, just like religion or just like national origin, you may as well get used to these things. Well, there's a number of times I've seen it says you can't marry. That's an illegal condition. We ignore it. The wife owns the property free and clear of any restrictions. All right? Now, here's a subtle difference that isn't against public policy. There's really no difference. I've seen this in deeds. To the wife, she can own the property until she gets married. Okay? The idea there is that the husband